Good morning, everybody. We're here for the case of Progressive Select Insurance versus Curtis Whitehouse. It's case 23-2271 and consolidated with 23-3521. We'll wait 1 moment for Judge Lambert to return. All right, I'm Judge Jim Edwards. With me are Judges Lambert and Harris. Since there is a cross appeal, does the cross appellant want to have separate rebuttal time, or do you want to just deal with your rebuttal during your first 20 minutes?
Appreciate 5 minutes of rebuttal time, Your Honor.
Okay. All right. So we will go appellant, appellee, appellant, and then back to the appellee. And for the appellant, how much time do you want for rebuttal?
5 minutes, Your Honor.
Okay. If everybody's ready, we'll go ahead with appellant's counsel. You may begin.
Thank you. Good morning, Your Honors, and may it please the court. Francesca Stein on behalf of Progressive. The question in this appeal is whether a claimant can recover his attorney's fees incurred in a UM case as damages in a subsequent bad faith action after the claimant requests and obtains a confession of judgment against the carrier. Since recovery of attorney's fees incurred to prosecute a UM case is an element of damages in a bad faith case under section 627727 and 624155, the answer to this question is no. This court should reverse and remand the trial court's order, awarding Mr. Whitehouse $40,000 of unproven damages with instructions to enter judgment in accordance with the confession of judgment. The pre-tort reform version of section 627727, applicable to this case, precludes an award of prevailing party attorney's fees in favor of an insured in a UM action unless UM coverage was disputed. But for the disputed coverage exception, fee shifting is not statutorily available when an insured sues his UM insurer to obtain benefits under the policy. However, if the insured brings a subsequent bad faith action against the insurer, as was the case here, the recoverable damages may include attorney's fees incurred to prosecute the UM action. Thus, the attorney's fees from the UM action are part of the damages awardable in the bad faith case. These damages,
Counsel, let me interrupt you for a minute. In terms of the confession of judgment, once Progressive paid the excess portion of the verdict, that's what was considered the confession of judgment, wasn't it?
Your Honor, we believe that once plaintiff moved for entry of a confession of judgment, that
before we get there, the consequence of Progressive paying the excess judgment is it was considered to have confessed judgment at that point, correct?
As to the excess verdict, just as to that $120,000, the additional damages after that, which could have included his attorney's fees incurred to prosecute the UM case, Progressive did not confess to that.
Okay, but counsel, in the motion filed by plaintiff for the consent judgment, they specifically asked that the court reserve jurisdiction to award fees and other damages available under the statute. And in fact, what the court entered was not a final consent judgment, but a confessed partial final judgment for plaintiff, which specifically reserved jurisdiction to determine fees, correct?
Yes, Your Honor, but the court, once the plaintiff requested the confessed judgment, he cut off his ability. He agreed that those were the damages he consented to. He agreed that the $120,000 was damages he agreed to, and Progressive agrees to that. However, once he moved for that confessed partial judgment or confessed final judgment, that was the verdict. The case was over. There was nothing left for the trial court to do, and solely because
can't a trial court conduct a trial or a case in sequence? In other words, often the case where punitive damages are sought first. You determine whether there's liability for the underlying cause, then whether punitive damages are recoverable. Then, as a sequence, you determine what the amount of punitive damages are. I mean, here, by the plaintiff moving for a confession of judgment as to bad faith, that issue was decided. Progressive doesn't contest that. And plaintiff asked for the court to reserve jurisdiction to determine fees and the amount of fees. And that's what the judge did here in the confessed partial final judgment, isn't it?
Yes, but once it's still an element of the attorney's fees in the action is an element of damages in the bad faith case. It's not a fee shifting provision where the plaintiff could request, where it could be done ancillary to the case. It had to be proven before that verdict was entered, or the confessed final judgment, which amounted to a verdict, was entered in the case. And without that, plaintiff didn't prove any damages as far as the attorney's fees go. So the case was over, and there's just simply no case in Florida that allows a plaintiff to have a judgment, or there'd be a verdict, and open that back up and then prove previously unproven damages.
Which case do you say was over by the confession of judgment?
The entire bad faith action.
Okay, but you already said that you didn't confess judgment as to everything. You only confessed judgment as to the excess verdict. So by your own statement here at oral argument, Progressive didn't confess judgment as to all claims in the bad faith. It only said we owe the $120,000, correct?
That's correct, but Progressive did not move for entry of confession of judgment. Plaintiff did. And the distinction is that once, if Progressive had moved for an entry of confession of judgment, we would agree that that would have likely been improper, because it would have cut off the plaintiff's ability to prove those additional damages. But when plaintiff moved for entry of the confession of judgment, he conceded that those were the damages awarded in the case, and he was happy with those damages, and there was nothing further for the court to do other than enter the confession of judgment, which amounted to the verdict.
Counsel, why then, how do you explain then in the plaintiff's motion, the plaintiff said we need to determine damages. We need, everything is taken care of except the amount of damages. That's the motion, and the judgment was yes. The bad faith is established by confession of judgment, by Progressive paying the excess, but we still need to determine attorney's fees. I mean, that's what was requested and reserved. That's what the final judgment was. And you already said the only confession of judgment you made was as to the responsibility for the excess verdict. So I'm really not following your argument too well.
Because we believe that once the plaintiff moved for entry of confession of judgment, he agreed that that was the end of damages. That was all that he was entitled to. And if he didn't prove those damages in the attorney's fees awardable for the prosecuting the case, that there was nothing further for him to do. The court had to enter verdict. And by doing so, he can't now reopen that verdict and prove damages that weren't otherwise proven.
Counsel, let's assume you're not going to win on that. Could you address what I think is the actual issue in this case? Is your opponent seems to think as to the amount of the damages vis-a-vis the fees, that the First Baptist Church case of the Florida Supreme Court is binding, persuasive, whatever term we want to use. I know that you cited to the second DCA case of Milling, and the trial judge did, and the Levesque case from the 11th Circuit. Tell me why or tell the court why the First Baptist Church, the decision of Florida Supreme Court's not dispositive here, and that it shouldn't be sent back for a road determination of reasonable fees.
Your Honor, there's a distinction here in the First Baptist case, because that case was based on an indemnity contract. So the fees in that case were ancillary fees under a fee shifting provision. In our case that we have here, it's a damage award. So the only awardable, it would be under Milling and Levesque, because the plaintiff, and I think the Levesque court says it very succinctly, they say the Levesques can recover as damages in the bad faith action the amount expended as attorney's fees in the case that would make them whole. They cannot make their attorneys whole for time and expenses above what they were agreed to pay their attorneys. And in this case, in the action, Mr. Whitehouse would only be obligated to pay his attorneys 40% of the verdict, which was that $100,000, which amounts to $40,000. And so for that, so the First Baptist case is distinguishable on that basis. And so we would represent that the Levesque case and the Milling cases are more appropriate. And the facts are nearly indistinguishable from this case, in that they recognize that fees are damages awardable in the bad faith action. And there's just, the plaintiff would have never been obligated to pay his attorneys more than 40% of the verdict, which was that $100,000. So he's not entitled to receive more than that. And it's not a lodestar calculation or a reasonable fee calculation. It's simply to make Mr. Whitehouse whole. And that's the $40,000 to make Mr. Whitehouse whole.
Yeah, it does seem odd that, if the Supreme Court in 2013 issued an opinion in First Baptist that's dispositive here, that two other courts well down the road would not even mention or consider that and just overlook it and say, no, this is a different route. We go on these things, especially the second DCA, since First Baptist actually quashed one of their earlier decisions. But you think that they had said, well, we learned our lesson on that one, and so now we know going forward here as to.
I
So
think
let me ask, in the UM case, so when the UM carrier gets sued, you don't deny coverage, but you say, well, we just don't think we don't think your damages will bring the policy into play. But the jury thought otherwise. They would not be entitled to fees from you, from the Progressive, and saying, well, we won on the UM case and now we're entitled to fees.
correct, Your Honor.
That's your predicate as to why then First Baptist doesn't come into play.
Yes,
There's
Your
no
Honor.
fee shifting when they won the UM case. And that's why your view is First Baptist doesn't apply. The cases of Milling, Levesque, or Levesque, however it says, that's more analogous factually and legally to what's happening here. That's your
Yes.
position?
Yes, Your Honor, that's exactly our position, is that it's just an entirely different basis to award fees, which is ancillary to the bad faith action or the UM action for that matter. And so as a damage award to make Mr. Whitehouse whole is just that $40,000 if he was entitled to recover those fees as damages at all, which of course our position is he wasn't, but presuming otherwise, it's just the $40,000.
Counsel, under the two applicable statutes here, if you look only at the UM case, if they had recovered within the UM policy limits, it wouldn't be a bad faith case typically, and you wouldn't owe their attorney's fees, correct?
That's correct, Your Honor.
But because they got the excess verdict and y'all confessed judgment on the bad faith issue, you had committed bad faith. That brings the bad faith statute into effect, and it does in fact shift fees over to you to have to pay their underlying fees, correct? I mean, I understand your argument about their waiving it by the confession of judgment, but putting that to the side, if everything had gone exactly as you say it should have, you would still owe their underlying fees. It's a question of the amount, correct?
Not necessarily. If assuming we're in the position we're in, which is that there's an excess verdict and there's the bad faith case, we would owe the UM fees as damages in the bad faith case, but we could potentially also, which is different than if we would owe collateral fees under a fee shifting basis for prosecuting the bad faith case. They're entirely different.
I understand that, but for this statute, you wouldn't have any responsibility for their UM fees, correct?
That's correct, Your Honor.
So in fact, the statute does shift the liability for fees from the plaintiff to the insurance company, correct?
That's correct, but as a damage award.
Okay,
So
but
it's not the reasonable.
does it, and trust me, we've all read the cases, but the statute doesn't say what kind of damages, it just says damages, correct?
That's correct, Your Honor.
Okay. All right, so it could have said compensable damages, but it did not.
It does not say compensable damages, but the case is interpreted as a compensatory damage because it's a damage awarded it's an element of the bad faith case. An element of the bad faith case is the attorney's fees for prosecuting the UM case.
Right, and I'm sure we're going to hear from the appellee about the Supreme Court case that describes bad faith awards as penalties. What do you have to say about that?
Our position is that the penalty is having to pay the fees at all because, like you said, Judge Edwards, Progressive would have not otherwise had to reimburse or pay out any attorney's fees from Mr. Whitehouse prosecuting the UM case. So the penalty itself is simply having to pay fees at all, not that the fees awarded could be greater than what was necessary for Mr. Whitehouse to make Mr. Whitehouse whole.
Okay, and by the legislature using the word or the words reasonable attorney's fees, do you see that only as a cap on what the contingency agreement could be?
Yes, Your Honor, and had there been potentially another basis for Mr. Whitehouse to recover fees in that case, maybe a PFS or something like that, then maybe that reasonableness comes into effect. But where there's no other basis other than just simply a damage in the bad faith case, it's just the fees would be whatever is to make Mr. Whitehouse whole. And in this case, it's that $40,000 that he agreed to pay his attorneys.
Well, let me ask, can they recover attorney fees for the prosecution of the bad faith action itself? But your
There's a
position,
fee. Yes, Your Honor.
your position is, well, that's not much because we ended it in 2 days.
Yes, exactly.
That
Your
your
Honor.
position? So if you would have gone toe to toe, then they could say, well, we were entitled to damages under the fees as damages of the bad faith. And then they've incurred another X number of dollars in attorney fees in prosecuting the bad faith case successfully. And then under Roe, they would be entitled to fees, or the lodestar would then apply there. And then you guys would be obligated under that.
Exactly. That's our
But
position.
we're not talking about that. That's not on the table today.
Correct. That's not before the court, that order. That's correct.
All right, counsel, you're right at your rebuttal time. Do you want to save the rest?
I will save the rest of my time. Thank you, Your Honors.
All right, thank you. We'll go now to appellee for your response to the initial argument, and then we'll look forward to your rebuttal of their rebuttal later. So go ahead.
Good morning. My name is Jessie Harrell. I am here on behalf of the appellee / cross appellant Curtis Whitehouse. As to the initial argument, I feel like the court is pretty comfortable with our position that the confession of judgment operated only to confess that they had acted in bad faith, and the court could appropriately reserve jurisdiction to consider damages. And essentially, Progressive was trying to do what a long line of cases say you cannot do, which is cut off a plaintiff's entitlement to damages through the expedient of paying, through confessing judgment, paying an amount after a suit has been filed, but before there's an actual judgment. I have a much longer argument prepared, but I feel like the court wants to hear the meatier reasonable attorney fee argument. Are there any questions before I'm on the first appeal before I move to the second issue?
Not for me. I think you can move on then, counsel.
Fantastic, thank you. I think both parties touched on this in the briefs, and I think it's really important to really look at the history where we began with bad faith in 624-1557, which said upon adverse adjudication, the insurer shall be liable for damages together with court costs and reasonable attorney's fees incurred by the plaintiff. So in the McLeod case, the Supreme Court said, well, because we're talking about damages, we're going to interpret that as compensatory damages. So in a first party action, you can't get an excess judgment because that didn't damage the insured, wasn't anything the insurer did that caused that damage. But perhaps telegraphing to the legislature, it said the legislature has the right to modify the common law definition of damages and allow recovery for amounts not proximately caused by the insurer's bad faith. And the McLeod case, it also noticed that it had comments that an element of the damages would be the fees incurred by the plaintiff. Almost immediately, the legislature came back and enacted 627, 727, 10, which is now 9, but 10 is what we were operating under in this case, and defined damages as to include the amount in excess of the policy limits, any interest on unpaid benefits, reasonable attorney's fees and costs. And so the legislature did exactly what the Supreme Court said it was entitled to do, was it redefined damages. It said, we're not talking about compensatory damages, we're talking about statutory damages. And one of the elements of the statutory damages you get are your reasonable attorney's fees and costs. And Milling and Levesque both erred because they read the word reasonable out of the statute, which we know we can't do. We can't treat words in a statute as mere surplusage. And as Chief Judge Edwards hinted at, because there's no way of otherwise establishing what your reasonable fee would be in a case until there's a determination of bad faith, if Progressive's position is correct here, the plaintiff can never be entitled to recover the reasonable attorney's fees mandated by the statute. Instead, fees are always going to be tied to the amount of insurance that someone obtained, which has no relation to reasonableness. And the courts have very consistently, from Roe on down, I mean, the whole purpose of Roe was to establish a universal method of determining a reasonable fee when a statute tells you to set a reasonable fee. And after the enactment of 627-727, then the Supreme Court was called on to determine whether the statute would apply retroactively, and it said, no, it cannot, because it's a penalty, and it significantly alters the language used to define damages. And just in 2023, the Ellison Supreme Court came back and said, it's a penalty, but because it exposes insurers to damages they did not cause. So this whole idea
Let me ask you a little bit about this penalty thing.
Yes, Your Honor.
So it's intended, excuse me, to punish bad faith of the insurer?
Yes, Your Honor.
And the only way to calculate that penalty would be through the lodestar method.
Yes, because the legislature specifically said we get a reasonable attorney fee.
So simply awarding the contingency fee amount would not be a penalty. Is that right?
It would be a penalty, but it wouldn't be the penalty that the legislature called for, because the legislature called for a reasonable attorney's fees. And just as an example, in this case, we know that 531 hours were expended between the civil remedy notice and the completion of the case, which would amount to $75 an hour for these attorneys.
Can an insurer engage in the same bad faith conduct against an insured who does not have an alternative fee agreement?
Yes.
So we're only penalizing bad faith conduct if the insured has the alternative fee agreement.
No, Your Honor, because I agree that any fee at all is a penalty, but because the legislature specified, there's really a couple things at play in that question. The legislature specified that you get a reasonable attorney's fee, but then Roe also said that in no event can the fee be higher than what the client agreed to pay, and that's where the alternative fee agreements come into place, because they specifically authorize the recovery of the reasonable fee when that is called for, because the client is actually obligated to pay that. And I'm hearing from Progressive that the client isn't actually obligated to pay it. They 100% are. That's what their fee agreement says. And so it's not a windfall to the plaintiff here, which I think was argued a number of times throughout the brief. And so there was really an interplay there. Did that answer your question?
Well, yeah, I mean, I think so.
Okay.
But counsel, on that statutory provision, it talks about damages recoverable, and damages usually refers to compensatory damages. And when you're talking about a penalty, the statute doesn't refer to it as a penalty. It doesn't say they shall be punished as a sanction, anything else, which we know those words are throughout the statute books and rule books at different places, but not here. Here it talks about damages. And if your damage is you are on the hook for 40% or $40,000, you're damaged to that extent because you had to sue and the insurer acted in bad faith. But here is the reasonable attorney's fees simply a cap on what the insured and the insured's attorney can agree to?
No, Your Honor. And in fact, I would direct you to the Fort Huber case, which you may recall you were on that panel from the 5th. And the attorney's fee agreement in that case also was not a cap. And the court first said that when a statute calls for a reasonable fee, you typically determine that amount under Roe, and that ordering only the reimbursement of fees, which is what the insurer was arguing for in that case, ignored the plain language of the statute and distorted its objective. And also that the insurer would reap a windfall if they weren't required to pay the reasonable fee. And so here, although damages would typically connote a compensatory damage, that's why the history was so important, where McLeod said, we're going to interpret this as compensatory damages, but you legislature are free to redefine damages as they would have been known under the common law. And that's exactly what the legislature did, because the excess judgment in a first party case is not a compensatory damage. And that's why the Supreme Court has said it's a penalty. And so why would, in the face of the legislature coming back and saying, we intend these to be the damages that are awarded in bad faith, and recognizing that not every element of that is compensatory damage, but then limit a reasonable attorney's fee to only a compensatory damage? They're all in the same sentence. And to do that essentially renders the word reasonable surplusage, because it ties the amount of a fee that a plaintiff can recover to the happenstance of how much insurance they happen to have. It actually incentivizes insurance companies to act in bad faith the lower the policy. And
Well, let me ask, so I mean, your position is that First Baptist basically directs the result on this second part of the argument today. Explain to me, I mean, I know you weren't there, but your best explanation to me as to how both the second DCA and the 11th Circuit could have so missed this. In fact, the 11th Circuit going so far as to say there actually isn't a Supreme Court case that talks about this, when your position, unless I'm mishearing this, is that just look at First Baptist. That gives us the roadmap here. How did those courts get it so, not only analyze it wrong, don't even consider, just completely miss it?
I believe that, I mean, obviously I wasn't there, but if you look at Milling, the issue in Milling was whether you could even award attorney's fees under 627, 727.10, because there's an alternative statute that says you don't fee shift if in a UM case, right? And so the trial court had said it would be adverse to that statute to award any fees. And the plaintiff in that case came back and said, well, we're not asking you to fee shift, we're asking you to award these as damages. And so the whole issue went a different direction because of what had happened below. And the Milling court focusing on them being compensatory damages, which is I think where it went off track here, and perhaps wasn't even asked to analyze it in terms of being a statutory damage and a compensatory damage, treated it solely as a compensatory damage. And Levesque picked up on Milling because it was obligated to follow the Florida law. And it went a step further and said, well, because there wasn't a determination in the UM case of the reasonable fees, we're going to cap them at the amount the plaintiff is actually obligated to pay in the UM case, which is the 40%. But again, that ignores that these are a penalty, that these are statutory damages and not compensatory, and that the Supreme Court in First Baptist recognized that even when someone is being reimbursed for damages, which, Justice Lewis's dissent in that case really makes it clear that that's what was happening, that this indemnity agreement was giving plaintiff the attorney's fees as damages. When that happens, you're entitled, if you have an alternative fee recovery agreement, you're entitled to use Roe and the Lodestar method to calculate a reasonable attorney's fee, even if it results in paying more than the plaintiff was initially obligated to pay, because the contract actually obligates them to pay a higher amount if it's awarded by the court. And so that's a long way of saying why I think they went so wrong, but that's how I think we got there, because Milling sort of came at it from a different angle initially. And I'm not sure that these arguments were ever fully teed up in front of it.
But I mean, I'm just looking at these cases, they look like they had some fairly competent counsel representing the party who wanted the plaintiffs, for lack of a better term.
Absolutely.
And I guess that just where I'm trying to get past is saying, as I read your position, or I hear your argument, is First Baptist makes it clear that there's no ifs, ands, or buts. Yet some very good courts with some very good plaintiffs, lawyers, appellate lawyers arguing this just missed the whole boat and didn't say, hey, don't get lost in the weeds here, everybody. Look at First Baptist decided in 2013. That solves all of our problems. That just raises a flag to me, a red flag or whatever color flag you want to use. That's just my editorial comment. That's not really a question.
I can't disagree that I think the court should have picked up on this and interpreted it differently. But even if they didn't find First Baptist controlling, you still have to go to the fact that these are a penalty. These damages are a penalty. They're a statutory damage. You look at the legislative history. You look at the
well, let me ask. Back in 1995, the Supreme Court in Lafayette was talking about, when an insurer violates the bad faith statute 624-155, it says it may be liable for damages approximately caused, including costs, attorney fees, and interest. And then it goes on and says, and a penalty equal to the excess verdict, and a penalty for willful or reckless behavior. So back then, they're laying it out saying, these things are the damages, and here's what we call penalties. Is that no longer something that should be informative to us?
It could be informative, but I do believe it's dicta, because the issue in Lafayette wasn't whether the issue in Lafayette was really whether the statute could be applied retroactively, and the court said no, because the penalty of the excess judgment is new. But again, there's no indication that they ever analyzed whether the remainder of the statute, which they continued to classify as a compensatory damage, whether that was actually accurate in light of the way the legislature specifically stated you're entitled to reasonable attorney's fees. And we know from the initial statute, 624-1557, that bounded attorney's fees to reasonable attorney's fees incurred by the plaintiff. If incurred by the plaintiff in the UM case had been the intent, that could have been in 627, 727-10, but it wasn't.
But you were saying Ellison, though, was talking about this being a penalty.
Yes, Your Honor.
Isn't that dicta in Ellison too? Ellison, that really wasn't the issue of, they were talking about what is collateral source under the statute is where their holding was. So
they were explaining why the damages in the bad faith case were not a collateral source, and it's because they were extra contractual and they were a penalty.
Well, we've learned here at the Fifth that just because we read words out of a Supreme Court decision and then tend to apply them, they might come back and say, well, that wasn't really I know we wrote that, but that wasn't our holding. So what are you doing? In fact, I think Judge Edwards and I were on a case that we were told that we were reading things.
Counsel,
we're taking too much in the dicta here. So.
Counsel, you've got about 3 minutes left for your rebuttal. You can use your time as you wish. So you want to? Okay, fine. All right, we're back to appellant's counsel. Thank you.
I'll be pretty brief. I just want to address a couple things. The Levesque Court cites to First Baptist, so I believe that the Levesque Court read the case, saw the case, relied on the case, and if they found it to be binding, they would have said so. And the Levesque Court specifically said there was no Supreme Court case that addressed that issue. So I think that might address some of the concerns here as well. I also think that to the extent there were any entitlement to fees here, I think Milling and Levesque are right on point in this case. And so we would just respectfully ask this court reverse the trial court and conclude that Mr. Whitehouse was not entitled to seek his compensatory damages in the bad faith case. But alternatively, if the court affirms on that issue, Progressive would ask that this court affirm the trial court's finding that Mr. Whitehouse was only entitled to recover the compensatory damages he was obligated to pay his attorneys pursuant to his contingency fee agreement, which was 40% of $100,000 or $40,000.
All right, unless my colleagues have questions, we'll go back to appellee.
Thank you, Your Honor. I would just point out that aside from milling, I don't believe that there is another Florida case that establishes a reasonable attorney's fee in a way other than a Roe methodology. That this is how we define a reasonable fee. And so the legislature certainly knew that when they used the word reasonable fee. I mean, Roe was in existence long before 720. I make up numbers. I'm sorry. 627, 727, 10 came into existence. It understood what a reasonable attorney fee meant. And so our position is, with all the background, all the case law, the legislature understanding that it was amending how statutory damages are calculated from a case when there's bad faith, that it would be contrary to legislative intent to ignore the word reasonable. Touching just briefly on the first cross appeal, because I didn't want to leave it out, we had asked for determination that we're the prevailing party on that first cross appeal because the trial judge inadvertently left out interest and reasonable costs as things he was reserving jurisdiction on. Progressive has since paid those after we had to incur the filing fee. And so for purposes of prevailing party costs, we would like to be declared to have prevailed on that since Progressive has paid those. But more broadly, we would ask that you affirm the main appeal, that the trial court acted well within its jurisdiction or its authority to retain jurisdiction after Progressive confessed to acting in bad faith, which is something it has never denied throughout this litigation, that it treated Mr. Whitehouse in bad faith, but to reverse as to the amount of reasonable attorney's fees to which he is entitled in the action and allow the trial court to determine that on remand. Thank you, Your Honors.
All right, thank you very much. Very interesting case. We shall be in recess.
Thank you.
Thank you.